Be welcome. I'm Professor Manuel David Maceno from the Polytechnic of Beja in southern Portugal. Today, we'll deal with one of the most relevant and sensitive subjects regarding cyberspace regulation. We'll deal with the protection of children online by European Union law. Outline. We'll deal with 5 subjects, 5 main issues, problems to be addressed, self-regulation, the alternative of trying to blocking the access, also the way of regulating data protection, and finally, mostly from a theoretical point of view, since all these issues are interconnected, criminalizing behaviors. Problems to be addressed. The special vulnerability of children online. Access to digital contents from early ages. Well, not so long ago, parents, families, educators, society in general were able to preserve children from sexual predators and also from sexually explicit contents. Contents that might harm, be very bad for the psychological and emotional development of children. And that contacts with materials, with pictures, with texts, but also with persons that might harm very badly children. Now, the situation changed, and changed in a very difficult to deal with way. From very early ages, children of 2, 3 years, very young children, are able to pick a smartphone, a tablet computer, a notebook, get into the internet and being exposed to menaces without the watch of adults and being, well, under the sight, or even worse, being fair prey for disturbed people, meaning pedophiles or professionals that want to make a profit from the need of pedophiles for access to children or to child pornography. Under menace from adults. Usually, children, and still now, children are under menace mostly from persons that surround them, in the family, neighbors, sometimes educators. But now, within the information and network society, the menaces to children came from everywhere. They came from a screen. They came from an instant messaging device. Lack of parental control. This is a problem. Most parents are not able technically to watch what their children are doing. Other times, they are not even willing to do it. They are let young people to deal with, to play. That's what most parents think their children are doing. Play with smartphones or with tablets and computers, with video games. They do not know, and sometimes they do not care if their children are under menace. So, since children are an asset of our society, institutions had to get into the problem. Self-regulation, the first answer. Self-regulation, the soft alternative. The recommendations of 1998 and 2006. Well, this program deals with the European Union, notwithstanding with the initiatives of member states. The Union, and by this I mean the Parliament and the Council, came forward at 1998 with guidelines, not compulsory guidelines, intended to let broadcasting companies and content providers of internet to take care of what they are making available to young people. Let them organize themselves, each one, just showing them objectives and let them go. This was not enough. And by 2006, a new recommendation, and I remember you that all these documents are available at the university's webpage. A new recommendation came with a new agenda. First, media literacy of people in general, mostly parents, became an objective. Let people know what they are dealing with. But also, well, compelling, it's a way of saying it, media to dialogue with them, with each other, and interchange information, interchange good practices. The safer internet programs of 2005 and 2008. Well, this time, the initiative of the European institutions did not regard media, but the society itself. Children, their parents, and concerned persons. I would dare to say everybody. The idea to be, or was meant to be, to educate, to let people understand the environment, this new electronic environment, in order to protect themselves from menaces. This, together with the European strategy for a better internet for children, 2012, this is what we have in place now, was also designed to improve the awareness of civil society towards these problems. menaces to children from the internet are no long something apart from mainstream. It's one of the greatest dangers to children and young adults, not just at the European Union level, but worldwide. But how to prevent the access from and to children online? Through the codes of conduct of EISPs. Now let's forget traditional media, even electronic media, TV. It's not difficult to control what is broadcasted by TV. There are not so many providers. But in the internet, there are many, and almost from everywhere. But most content providers reach our homes through ISPs, Internet Services Providers. And these providers, even if they do not have a duty of surveillance to watch what goes through their cables or is at their data banks, they have a duty, maybe not a legally bounded duty, to have criteria and implement those criteria through contracts with the persons that create and distribute content. Since having each ISP different policies, the best way was to create industrial references, codes of conduct that could be also evaluated by, in this case, European institutions. The other way to try to do something is by parent-controlled filters, making advisable, I would not dare to say compelling, software that would allow parents to choose what contents will not be made available to their children. This has to be done not just with ISPs, but also with content providers. For technical reasons, pornographic or sexually related content had to be marked in order that filters were effective. Now, we'll be able to answer to what have been the concern and EU policy answers to online menaces to children. Also, what are the available alternatives for preventing menaces to children online? And also, even, what are the legal limits of those measures? Just remember that here we are dealing with very sensitive issues like privacy. You cannot survey everything because that would hamper other people's liberty. blocking the access. It's another sort of answer. Member state restrictions of information society services under the Electronic Commerce Directive. Well, we've just seen that an issue of within self-regulation would be providing control of access filters to parents. However, an upstream approach is also possible, meaning that not letting that information arrive not to our homes, but to our countries. Well, the European Union is based on the free flow of information and information society services. However, the 2000 directive on e-commerce that deals with information society services explicitly allows member states to not accept services provided by companies established in other member countries if the contents provided somehow are in contradiction with human dignity. For this, I mean that some countries are more liberal than others, accepting or not some contents. So it's possible, and it's compatible with European Union rules, to simply block access to the internet of content, if in this case the objective is to protect children. A country might decide we will not accept these contents, and providers have to filter it in a mandatory way. Well, besides, member states measures containing child pornography under the directive on sexual abuse, sexual exploitation of children, and child pornography. It's a directive of 2011. I'll be asking you to have the directive in hand. You may pick it from the university's webpage. And at the directive, I have the directive in hand. You should also have it printed or not. You may have it in a different screen or in your tablet. In this Article 25, it says that member states shall take the necessary measures to ensure the prompt removal of pages containing or disseminating child pornography hosted in their territory, and also to endeavor to obtain the removal of such pages hosted outside of their territory. It's not just blocking, it's shutting. It's a way of, well, in a large sense, it's blocking, but just preventing all this content to arrive to children. Then, point 2 states that member states may take measures to block access to web pages and ask other countries to do the same. However, you need to be aware how sensitive this is. It's not a matter of freedom of expression, but sometimes the frontier between censorship and politically condemnable censorship and protection of children is blunt. So, you find in the directive guidelines to equilibrate between protection of children and rule of law. Another answer, or another way of dealing with these subjects, regulating data protection. The insufficient protection of children in the current EU framework of data protection. The European Union is about to have a new general regulation on data protection, but what we have now is a directive of 1995. This directive was meant to regulate the behavior of adults. In the beginning of the 90s, not many children and young people were online. It was more a subject that concerned companies and professionals. So, we have the problem of data subjects consent. The idea of awareness of the consequences of consent for the management of data. However, children or non-mature persons were not taken into consideration. This is still one of the weaknesses of the directive. This directive also deals with sensitive personal data, meaning data on health, political opinions, religion, data of certain content related to people, let's put it this way, that needed, well, special protection. However, we would need a very over-the-board interpretation to state that also children would be included in this higher level of protection. And now, children protection in the proposal of a general data protection regulation of 2012. As I told you before, this regulation that was proposed by the European Commission in January 2012 is about to be adopted by the European Union. The European Parliament has already approved it, and well, by the end of 2014, beginning of 2015, it's foreseeable that we have this new regulation in place. Special consideration of children's personal data. It's one of the novelties. This regulation takes children in a special manner, as persons in need of protection, explicitly. The availability of information able to be understood by children. For this is meant that if you are asking the consent of children, and children from 13 years old on, in order to process their data, the way you ask them and you show them the consequences of the acceptance had to be shown in a way that children can understand. The right to be forgotten and to erasure. that's possibly the key issue in this new regulation. Children, young people, are not aware of the consequences for the future. They take, for instance, pictures of them naked or in parties or after drinking or worse and put them in social networks. They are not aware that in the future that information might affect them very seriously. So this right to be forgotten is of paramount importance. For instance, it would let someone arriving at 18, when becoming an adult, to decide what was due to inexperience and maturity and be erased from the internet, even if it's not technically easy to erase anything. Well, at least we have an hope. Now, we'll be able to answer to why is personal data protection so relevant for children, but also as future adults. Criminalizing behaviors. We are now arriving at the strongest, I would dare to say, heaviest part of our lecture. When criminal law is asked to help protecting the core goods in our society. The international legal framework of criminalization, the optional protocol to the Convention on the Rights of the Child, on the sale of children of May 2000. This protocol at UN level, one of the issues is child pornography, and each country is asked to fight it. Take care of child pornography. Not pornography at large, but child pornography. The same happens with the Council of Europe Convention of Cybercrime. The convention signed at Budapest the 23rd November, 2001. This convention, it appears to be an European Union one, but it's not. It was drafted within the Council of Europe. But other countries, the leading countries of non-European continents, the United States and Canada, Japan, or South Africa, participated in it. And it's law there. Besides, in the last few years, Australia or Panama or Mauritius or the Dominican Republic or Georgia became parties of the convention. And this convention is the world reference. Also, it has provisions on child pornography. And from this convention, we have a difference that we'll see later about real child pornography, apparent child pornography, and virtual child pornography with different consequences. As several member states of the European Union were not about to ratify in the near future the convention, and still now several countries like Poland or Sweden or Malta or Luxembourg did not ratify it. Well, the European Union had to put forward an alternative. In these times, beginning of 2002, 2003, the Union had no competencies in crime issues, but in the third pillar of judicial and police cooperation. So we had a Council framework decision, Council framework decision 2004-68 GHA of 22 December 2003 on combating the sexual exploitation of children and child pornography. This, regarding child pornography, we are dealing with online issues. We had put as crimes the production, the distribution, dissemination, or transmission of child porn, the supplying of making available child pornography, and also the acquisition and possession of images. And at the same time, we had provision on the legal liability, on the liability of legal persons. But we'll go on with the new EU legal framework. The framework decision is now passed. We'll go, what do we have now? The reference to crimes regarding sexual exploitation in the EU law by the Treaty of Lisbon. With the new treaty that became effective by the end of 2009, we have now a catalogue of relevant crimes that might be addressed at EU level, including the sexual exploitation of children. So, the following criminal policy statements. The Stockholm Programme of 2010. After the Treaty of Lisbon, the European Union approved a new conceptual framework and new objectives. At the Stockholm Programme, dealing with the liberties and the implementation of liberties at EU level, one of the key issues is cybercrime, and within it, or intertwined with it, is fight against child pornography. Well, in the Commission communication of 2001 and 2011 and 2012, we have both a catalogue of principia in the sense that the European Union will follow the common core of European criminal law with a strong perspective of proportionality, of the protection of human rights, more than providing security, more than punishing people. And then, since 2012, and from the beginning of 2013, we have now an European Center on Cybercrime. And one of the main tasks of this center is the fight against child pornography. But we also have now a legal answer. The Directive 2011-92 EU of the European Parliament and of the Council of 13 December 2011 on combating the sexual abuse and sexual exploitation of children and child pornography. Reasons for the adoption. What you have now, not just a possibility of putting forward a framework decision, crime related to children is the competence of the Union. Besides that, the Charter of EU fundamental rights also address the rights of children. There are legal reasons, but also technical reasons. Now, you can watch online by streaming the abuse of children without possessing any images. And this is a major issue. You can watch a child being raped and you would not be punished under the framework of the previous decision. And that would be preposterous. So we have in place a new directive. Well, legal basis. Now with the Treaty of Lisbon, we have 83 of the Treaty for the functioning of European Union. That's the base. The option for a minimum harmonization directive. This directive is the minimum. Member states are allowed to go further. They cannot have less, but they can have more and prosecute more. The offenses, child pornography, notions, and protected good. Here, as I told you, we deal not only with real child pornography, the depiction of children. And I ask you to watch Article 5 of the directive. Not just picture of actual children, but also other pictures that person might looking like children, or even other pictures. Here, we have to be aware that member states might have different approaches if not a real child is hammered. The protected good here, you may not say that these are children, but childhood in general and the way we think about it. May even say it's the dignity of the human person at stake. You also have the solicitation of children for sexual purposes. The problem here is that adults, mostly through social networks, ask children that do not know they are adults on the other side, most of the times, for meetings. And something has to be done. And in this time, it's organization of those meetings that would become a crime. And again, the protected good is the well-being of a real child that might be very harmed psychologically by a meeting with an adult that might be able or wanting to rape that child or to induce that child into child pornography. Other rules. Also, we have here the punishment of incitement, aiding, and abetting, and attempt regarding both child pornography and children solicitation. Consensual sexual activities, well, almost, of course, between children of about the same age, there would be a different leaning of the law. Even if they produce pictures of them having sex. But his tolerance due to younger people. We have also aggravating circumstances. If that given child is under protection of the adult and should rely on a given adult, or that child is so young, has no way of consenting whatever. Liability of legal persons, the same. If someone is about to make a profit out of child pornography, and that someone is a company, that company has to be punished, not just the persons in charge of it. And leniency toward the victims. Even if a child is aiding an adult, for instance, inducing other children into child pornography, that child is also seen as a victim and has to be protected and not treated like an adult, even if that child has 15 or 16 or 17. Well, extended jurisdiction of member states, in the sense that a member state will be able to persecute anyone being in his territory, not even national, but if the crime has any connection with his territory. If the internet servers are placed there, or the pictures are available from that country. We have an extended jurisdiction rule. Also important is the coordination of investigation and prosecution between judicial authorities and law enforcement. And the idea of a network fighting child pornography and child solicitation is the only way to countermeasure international networks of pedophiles. In this moment, we'll be able to answer what issues are addressed by the directive. And also I would like you to think about it. Has the EU legislator gone too far? So, finally, I would like you to think if the European Union has gone too far in this sort of protection of the idea of children. If liberty, namely the liberty of expression, were not too hampered by these new regulations. Thank you.